My name is Erin Corcoran, and I'm the director of the Social Justice Institute here at the law school. And the Social Justice Institute, I think, is the place at the law school where we really try and show students the importance of giving back, of contributing, and part of one of the things we've been doing the last week is actually celebrating the life and work of Bruce E. Friedman, and who was a professor here at the law school and worked in the clinical programs and basically founded the clinical programs. And part of that has entailed students volunteering to do pro bono work this week and next week. And we actually have a pro bono challenge that's going on here at the law school where students are actually competing to see how many pro bono hours they are achieving. And I'm really proud of that, and I want to recognize Esther Dickinson and Coward Maynor for organizing that effort here at the law school. They've been real leaders in that, so thank you very much. And so I think it's so fitting as the week comes to an end that we're having the Frank Rowe Kenison lecture. This lecture series was started here at the law school in 1980 to honor the legacy and work of former Chief Justice Frank Rowe Kenison. And before I talk a little bit about who this wonderful man was and the work that he did and how his contributions to New Hampshire, I want to recognize Loretta Kenison, who's here tonight with us, who's the widow of Frank Rowe Kenison. We're so delighted that we are here to join you tonight. And I want to also thank Jan Newman for bringing her here tonight to us. I really appreciate that. And also want to thank Deb Page for all the behind-the-scenes work she's done to make this event happen. The purpose of this lecture series is to highlight the role of state court judges and the importance of state court jurisprudence. And we're honored here tonight to have the Honorable Wallace Jefferson, who's the Chief Justice of the Texas Supreme Court. And our Dean Broderick will be introducing him shortly. But I want to talk a little bit more about who Justice Kenison was and the legacy that he left here in New Hampshire. He was born in North Conway, graduated from Dartmouth, and received his law degree from BC, Boston College. He began his early career in private practice and then moved to be a prosecutor. In 1940, he was appointed to be the Attorney General of New Hampshire. After 2 years in that service, he left to serve in the U.S. Navy. Upon completing his military service, he came back and served as the Attorney General for 2 more years until 1946, when he was appointed to the New Hampshire Supreme Court. In 1942, he was elevated to Chief Justice, where he served as Chief Justice until 1977 for a period of 25 years, the longest term for a Chief Justice in our history yet to today. But more than his distinguished legal career and the successes and the benchmarks that he met, he was a distinguished jurist, a compassionate and humble man who worked to bring people together, to find common good. And those values were reflected on the bench while he served. He's often noted for his ability for the court to issue unanimous opinions and his ability to run the court in an efficient and respected manner. But I think what's even more moving about his legacy is his deep commitment to mentoring young, aspiring attorneys. Many people often note that they would see the Chief Justice wandering the libraries, going up and talking to young law students or attorneys to try and figure out how he could help them, what issue they were working on, what problem could he help them. And so I think what's really exciting to me is he was so dedicated to mentoring and encouraging people to pursue a career in the law, and his example was to show how to be a good lawyer and a good citizen. And so I'd like to ask another former Chief Justice who also deeply cares about helping law students do better in the world come up and introduce our speaker for this evening. Please join me in welcoming Dean John Broderick.
Good evening. Nice to see familiar faces. Two of the sitting members of the Supreme Court are here, and my former colleague, Joe Nato of the court. Thank you for coming. Wallace Jefferson just happened to be in Concord today. That's why he came. Wallace Jefferson, I first met shortly after he became Chief Justice of Texas, which I believe was in 2006. And I met him at a Conference of Chief Justices meeting. I'm not sure where it was. But you've had this experience in your own lifetime. You meet somebody casually and you watch them for 2 days, and they stand out. And Wallace Jefferson, although I was senior to him in status as a Chief Justice, it seemed like he'd been doing the job for a long time. He had a very nice way about him. I came to learn that he was a very distinguished lawyer at a very young age. By the time he was 35 years old, he had successfully argued 2 cases in the United States Supreme Court, which was just a few more than I had argued in the U.S. Supreme Court. He was an appellate lawyer in Texas of the first order and widely respected. In 2001, he was appointed to the bench to the Supreme Court, and in 2002, he was elected to that slot in Texas, winning a contested primary and winning the general election. 2006, he became Chief Justice of Texas, and has, on more than one occasion, I believe, been the highest vote getter of any state office holder in the state of Texas. You may have heard of Texas. It's a small state down by Arkansas. After a relatively short time as Chief Justice of Texas, Wallace Jefferson was selected by his fellow chiefs around the United States to be the president of the Conference of Chief Justices, which he did, I think, in 2010 and 2011. And so he represented the chiefs of America all across America for that year. And in many ways, that organization elevates people to that slot who have served for a long time. The chief had not served for a long time. That struck me as remarkable, too. So I wasn't the only person in the conference that saw his extraordinary talent. What most impressed me about him, however, was not that he was Chief Justice, but his commitment to access to justice issues, which were firmly held and deeply believed. I remember shortly after he became chief, I was at a session and he was recounting some of his life story, and that he traced his descendants to slaves. And I thought, what a remarkable journey he'd been a part of. He left home this morning at 4 a.m. He didn't tell me that, I asked him. So it's extraordinary that he's come. It's an honor to have you here, Chief. I said he was speaking this afternoon to a class here. And I told the class that he'd received an honorary degree at this law school last year. And now that he's back, he's probably wishing he hadn't accepted it. Once you get an honorary degree, there's some obligation apparently that goes with it. But the Chief is an unusual person. I think you'll see that pretty readily. It's an honor to have you in the building, and I have the pleasure to introduce Chief Justice Wallace Jefferson of Texas.
Thank you very much. The Dean, as Chief, was an incredible leader in the Conference of Chief Justices, and whatever he tells you about my commitment to access to justice, it pales in comparison to what he did individually, what he did actually for the nation, because many of us followed his example in our own state, so I want to thank you for that. Dean, Professor Corcoran, members of the Supreme Court, and professors and students, and especially Mrs. Kenison. It is wonderful to be here to share a few words with you this evening. I'm not so sure you will be pleased with everything that I have to say. Some of it is depressing. We want to know, all of us, that the future for our children is bright and that they will prosper in everything we do. And we understand fundamentally that this goal cannot be achieved unless we instill discipline in our kids. I have 3 sons, and my wife and I try to do that. Discipline is good. The root word is pupil, right? A pupil, like a disciple, wants to learn, wants to follow. Discipline is instruction and the proper path for virtuous growth. It is essential for kids. But in Texas, and that's what I want to talk to you about tonight, when we say discipline, we often mean banish. And when we banish kids from our schools, we consign a future generation to a very tough life. And that saddens me. Now, but my remarks aren't entirely depressing. When I speak on this subject in the Lone Star State, most people say that we can and that we must do better than we're doing. And they express a true sense of urgency. We don't have many years to help children mature in the proper way. And so what I'd like to do today is spend a few moments laying out the problem with school discipline as I see it, and describe some of the inspiring measures Texas has taken in the last few years, and then share a vision for the future. And by the way, the people in this audience, pupils, disciples, professors, the instructors, the judges, your disciplinarians, I fear, all of us here must accept responsibility to see what is going on. And I confess, I've only seen it for the first time recently. But then act. Gather the data, analyze and share it, and then get your legislature to help. And the good news is that we can make a difference. A recent Texas A&M study concluded that of the risk factors associated with future involvement in the juvenile justice system, the single greatest predictor is a history of disciplinary referrals at school. This so-called school-to-prison pipeline is a very real thing. 1/3 of all youth in a lockdown facility have already dropped out of school, and more than 80% of Texas adult prison inmates are school dropouts. 80%. So what went wrong in these young people's lives? Why do so many of our state's children end up locked and locked out of our schools? And how can we divert our youth from the courtroom to the classroom? And what part do schools and the judiciary play in this school-to-prison pipeline? Well, the overwhelming majority of the children sent to the justice system by their schools in Texas get there because they receive tickets. They're accused of committing Class C misdemeanors. What, they fail to attend school, or they disrupt class and distract the bus driver, or they're disorderly. And yes, in Texas, truancy can be a crime. A curse word, a crime. A ticket. And then this little kid has to appear in a criminal court for conduct that in my day would have sent me to the principal's office, or worse, to the coach whose paddle always hung menacingly in the gym. A child who received this type of ticket in school is told to report to a judge with a parent on a school day and on a work day to enter a plea. Rarely does a prosecutor see the case before a plea is entered, so there is very little opportunity for quick dismissal of a citation that lacks probable cause. And what if the parent fails to appear? The court proceeds. The children has no right to counsel, and many plead guilty even when they have a viable defense. So get this. More than 275,000 kids were ticketed in school in 2010 in Texas. A steady stream of kids going before courts. And when the gavel sounds, that kid has a criminal record. Now, that number has certainly increased in the last few years. The sheer volume would be staggering enough, but also consider this. African American and Hispanic students and those with mental disabilities get tickets well out of proportion to their percentage of enrolled students, and most often for disorderly conduct, disruption of class, and perceived party gang affiliation. But you say the kids must take responsibility for their actions. Well, let me go to science for a second. The National Geographic recently published a remarkable piece about the adolescent mind. Adolescents are far more likely than adults to engage in risk-taking behavior and are less able to understand the consequences because critical areas of their brain have not matured. Now, I didn't really need a study to know this. I have 3 teenage sons. But it's clear in the scientific literature that as the brain develops, the ability to control reckless behavior is enhanced. And because of this, arrests drop off substantially after adolescence, and the vast majority who commit a crime do not re-offend as adults. As the National Geographic put it, a shepherd in William Shakespeare's The Winter's Tale wishes, quote, that there were no age between 10 and 23, or that youth would sleep out the rest. For there's nothing in the between but getting wenches with child, wronging the ancientry, stealing, fighting. So let's, in that spirit, try a little experiment. Think back to when you were in middle school or high school. Now think of the worst decision you made at that age. Just think of it for a second. Would you do that same thing today? Would you fight with a coworker, Dean? Would you do that today? Well, don't answer that. Throw eggs at somebody's house, defy a police officer's commands because you hate authority? Well, see, today we appreciate how wrong, even criminal, those acts were, but our minds were undeveloped at the time. We were impulsive. Our capacity for restraint is much more refined later in life. So should we really be saddling our children with the criminal consequences of juvenile behavior when we know that the juvenile mind is so different? I think we should use this science to reevaluate how we discipline our children. Detention facilities should be reserved for the worst juvenile offender. Of course, society must confront those who commit violence, safety first in our schools. But short of violence, are police and judges truly the answer? Especially when student interaction with the courts increases the likelihood of dropout by a factor of 3. The problem today is not about the violent offenders. We'll take care of those. It is about those for whom discretion, subjectivity, those sorts of things accentuate problems of race and class that society has been grappling with for time immemorial. Utilizing the justice system in response to school discipline has dramatic effects that reaches farther than most people, even those who are part of the system, realize. Many times school administrators and prosecutors and even some parents and students downplay what it means to receive a Class C citation. It's just a ticket, they say, like a ticket for speeding, but it is not. Ticketing kids has countless negative consequences, not only for the child, but for the families, the larger communities, and for our courts. The kids who are ticketed in school, many of them are taken out of school to appear in court, and they experience devastating, lasting trauma. Imagine just the pure embarrassment of being singled out, possibly physically escorted out of your classroom by a police officer to engage the process of the justice system, something that itself must be confusing and frightening, even for an adult. This experience can make a child frustrated and angry and disengaged. School is no longer a place of learning and development, but instead a place of trouble and contact with police. In a child's eyes, teachers, principals, and school staff are no longer protective adults in whom to confide. They are adversaries who, the child believes, would rather involve a school police officer than address the myriad underlying problems that could be affecting his or her behavior. Now, to complicate matters even more, students may not only be subject to ticketing for misbehavior in school, but school disciplinary procedures like suspension, alternative placement, or expulsion. A 2011 study by the Council of State Governments Justice Center revealed that in Texas, nearly 6 out of every 10 students in grades 7 through 12 have been expelled or suspended at least once. We know this because Texas tracked this data. They kept it and they offered it up for study. They tracked millions of students. Now, I mentioned the disparity in rates of discipline for racial minorities and students with mental health issues. Well, the rates for violent offenses, those for which the school administrators have no discretion but to act, they bring a gun on school or something, well, those rates are roughly the same across all demographic groups. Approximately 90% of expulsions and suspensions are for discretionary acts, the things I was telling you about, the behavioral, the insubordination, the things that don't rise to the level of mandatory suspension or expulsion. Removing the child in those areas is a choice that the school administrator makes. Well, a disproportionate number are levied against minorities when punishment is at the school's discretion. So what is really going on here? The threat of criminal consequences for a child does not stop at the original ticket. Judges have the power to issue arrest warrants for students who fail to appear in court. A study of one court in Texas found that 30% of African American and almost 60% of Hispanic students who failed to appear in court for these minor offenses had warrants issued for their arrest. Courts issue a capias and fine kids and arrest the child. But once that child turns 17, if he has failed to pay that fine or fee that was associated with the Class C ticket, well, his driver's license may be suspended or revoked. Now, not surprisingly, children who are involved in the juvenile justice system are more likely to be involved in the adult justice system. A nationwide study determined that juveniles arrested before the age of 18 are 36% more likely to be incarcerated in the adult criminal justice system by age 26. And juveniles who are able to complete high school were 18% less likely to be involved in the criminal justice system. Once you are tainted with that criminal justice system, you can imagine the types of issues you face the rest of your life. Depending on the offense, and we were talking about this in class today, you might be limited in where you can live, or whether or not you can vote or serve on a jury, and whether you can get a job. Children receiving tickets for misbehavior in school may also be saddled with a permanent criminal record. You think in your mind of these juvenile cases are cases where the record is concealed and doesn't have to be revealed. But in Texas, you get a criminal record, a permanent criminal record. And it might be for throwing a paper airplane or refusing to remove your hat or chewing gum in class. For Class C misdemeanor cases, there is generally no automatic expunction or destruction of records. And for certain types of cases, when the child turns 18, you can apply for an expunction, but you have to do this in the same court where you were convicted. And you can imagine how difficult this would be for many kids and families, including the associated costs and the difficulty understanding and completing the application. Another major problem with creating these criminal records for children is that there often is no distinction between the offenses. So when a potential employer looks down and sees assault, there's often no indication of whether that is a verbal assault from a middle school kid, like I'm going to beat you up, or a serious instance of domestic violence. Between two otherwise equal candidates, a failure to attend ticket can indicate to an employer that there will be some failure to attend work issues that could knock someone out of contention for a job. The point is that these citations and court referrals follow the children into adulthood. They are not just a ticket. In most cases, a ticket is a temporary way to address behavior. They don't address the underlying problems that affect the child. And without that, we are rarely preventing future misbehavior. We are setting many of our children up for failure. Delegating school discipline to our courts, well, that also has consequences for a family. There is a significant amount of stress that goes along with having a child who is in the juvenile or criminal justice system. But as I've mentioned, there's also financial strain, as fines for Class C misdemeanors can be $500 plus court fees and court costs. And in failure to attend school cases, parents of children can receive Class C citations themselves, thus potentially doubling the cost for a family. And for a family with a limited income, there is little room for these kinds of expenses. In Texas, a child's involvement in the criminal and juvenile justice system could also affect the family's ability to obtain and remain in public housing. I've heard stories about the El Paso and San Antonio housing authorities attempting to evict families whose children receive Class C citations in school. Both the public housing and Section 8 voucher programs authorize housing authorities and landlords to have lease provisions that allow for evictions following criminal activity of any household member. And in practice, this includes children. The statutes allow for eviction for criminal activity, meaning there's no conviction is required, just for activity. And for these families, losing housing benefits is devastating, and many can't afford to defend themselves in an eviction suit. And our courts, many of them are overwhelmed with the growing number of school ticketing cases. Now, listen to this. There is one municipal court judge in Houston, Texas. He estimated that he sees approximately 150 juvenile cases every day that he's on the bench during the school year, every day. Our courts should be focusing our limited resources on providing services to students who may be faltering and need court intervention the most. But rather than punish behavior, we should be investigating its root cause to make sure that our children stay on track. Now, as I said at the beginning, all of this is depressing. But I don't mean to suggest that the state is completely hopeless, that our criminal justice system is beyond repair. There are several programs currently in place in Texas that are moving us in the right direction. For example, and you may have heard of this term, school-wide positive behavioral interventions and supports. That is a system that's aimed to address school discipline referrals, court involvement, and dropout rates through a method of remodeling and reinforcing positive student behaviors. And it's been proven a great success in a number of Texas school districts, and in some cases has reduced the use of disciplinary actions by half. In Bexar County, that's San Antonio, my home, a police training program called Children's Crisis Intervention Training teaches police officers how to recognize developmental and substance abuse problems in children, to de-escalate dangerous situations, and make referrals to community organizations that can assist families. With the help of local judges and other county initiatives, this program has proven successful and should serve as a model for educating other police officers in schools. And despite these programs, we still have a long way to go in Texas on behalf of our kids. I have discussed this issue in my State of the Judiciary address, which I give to the legislature every other year. And I think that it is important to remind our lawmakers that serious problems exist and that there are ways they can be fixed. The good news is if you get the attention of a lawmaker, you can make things happen. And just in the last couple legislative sessions, there have been bills proposed and passed that eliminate what was a common basis for this ticket, this, quote, persistent misbehavior as a reason for expulsion. Well, now that is gone. You can eliminate ticketing students in 6th grade and younger for nonviolent misbehavior. A statute was passed. Eliminate ticketing them for truancy. That statute was passed and signed by the governor. Things can happen if you involve the legislature. Additionally, I can, through the Texas Judicial Council, which is a bipartisan policymaking arm of the judiciary, I push for creation of a juvenile justice committee comprised of judges, school officials, police officers, juvenile justice officials, and others to study the problem. We have assigned them the task of assessing the impact of school discipline and policing on referrals to the courts and identifying policies or initiatives that will help to reduce referrals without having a negative impact on school safety, limit recidivism, and preserve judicial resources for students who are most in need of judicial intervention. That committee has already developed a number of preliminary recommendations based on its research. Some are meant to improve the information that students, parents, school administrators, police, and courts have about the discipline system. For example, we have proposed better data collections systems, because if you have the data, you can study it, then you can make your case more persuasively. And we are planning a summit, probably called a Shared Solutions Summit, to look at how discipline is occurring throughout our state. It's an amazing thing that you can have two schools side by side with the exact same demographics, and the rate of discipline in one school is high and the other one is virtually non-existent. We need to get these people talking and say what is happening in the school that has a lower rate of expulsions and discipline. And the committee has suggested drafting for students a Know Your Rights pamphlet and have online materials so that children and their families can learn more and prepare themselves for court processes. And we have other recommendations that are meant to directly address current laws that impact children involved in the criminal and juvenile justice systems. For example, one of the recommended reforms in legislation is, now this is expensive and it's going to be tough, but give children actually the right to counsel, to a lawyer, including those in Class C misdemeanor cases. And the committee is looking at recommending a rebuttable presumption that a child under the age of 15 does not have the criminal intent to commit Class C misdemeanors. And there are other recommendations that this committee is working on. Now, some of you in this room may yourself have direct knowledge of what I'm talking about, either here or in the communities from which you come. I really didn't growing up. My father spent his career in the Air Force. He was about 6'4" and 230 pounds. There weren't a whole lot of discipline problems in our home or at school. There were 6 kids, and we all went to public schools, and we didn't have any major trouble. So really, I didn't know about juvenile justice issues. I learned about it first by reading cases on my docket, juvenile justice cases, and this person was ticketed or arrested or convicted, that's not the proper term in Texas, but for some conduct. So I started seeing it that way. And then one day I arranged to attend juvenile court proceedings myself in Austin, Texas. And there, one day, I witnessed both human trauma, but also dedicated people who are trying to help these families. And I promise you that we can change lives for the better, one child at a time. I saw so many kids that were mentally disturbed, frankly, and needed mental health resources. But then I walked next door and I saw kids that were on meth, which is a big scourge I didn't know about in Travis County, and was amazed at the progress that they were making. I think we can change lives for the better. I think we need to use the law to reform the system, a generation at a time. I guess I was 14 years old when I read Ralph Ellis's Invisible Man, and he described a whole world of experience that exists in the shadows. There is today an invisible generation, not unique to Texas, that requires our immediate attention. And I saw it that day in Austin. The exhausted mother, still in her work clothes, asking the judge, "What can I do? My son is lost. I can't reach him. I work every day just to put food on the table. What do I do? Where do I go?" Or a young man plagued by psychosis who needs mental health help. Or a young girl strung out on meth who wanted nothing else but to show me how well she was doing in her class in the detention center. A teacher who is doing all she can to maintain control of her class, but who genuinely cares about all of her kids. There is another world crying out for notice. And the reason I'm here today, and pleased to be here, Dean, is that I want you to begin paying attention. Go to juvenile court right here in Concord. Be a witness, and then tell the judge that you want to help. Go to New Hampshire's representatives and senators. Is the policy of your state sufficiently attuned to the child's best interest? Or is it punitive? Does it lead to expulsions? And does it lead to interaction with the juvenile justice system? Is it, in short, a recipe for removing these kids from school and toward a life in the dark corners of purgatory? Now, I know that at least one person here tonight has heard me, and one person, well, that's a beginning. One person who's made my long journey here more valuable than my almost 12 years on the bench on the Supreme Court. But probably there are two people, so much the better. The message is that we can help kids in school, and I believe strongly that you, each of you in this room, holds the answer. And I would not have come here tonight if I thought that were not so. Thank you.
So thank you so much, Chief Justice. I was hoping we have some time, and the Chief has indicated his willingness to take questions from the audience. So we have two mics on either side of the aisle. If you can just come forward, and if you ask your questions, just speak into the mic, because we're videotaping this, so we want the questions to be on the record. So please, I hope you use this opportunity to talk to him about what he's speaking about. So.
Justice, I'm Michelle Wonger, and I actually run the Youth Law Project here at New Hampshire Legal Assistance, which is a school-to-prison pipeline project. And one of the greatest hurdles that I've faced is, like you talked about, a data collection problem. And in New Hampshire, I think that may be one of the greatest barriers to achieving reform. And you indicated that in Texas, that is still a problem that you face, and one of the recommendations of the committee that you are on. But also, one of the driving forces behind the reform that's already been done is the study that you mentioned at the very beginning of your speech. And I guess I wanted to know what the greatest factor is that, or how the researchers for that study were able to collect the data that then leads to the recommendation to collect more.
Yes. Fortunately, in Texas, for many years, there was a good collection from the school districts about that was required by the legislature about why are you expelling a student, and whether the students are expelled or suspended, and that data is collected by the Texas Education Agency or somebody. It's in the report. It's called Breaking Schools Rules, and you can look that up. And so the data was there, and it could be specifically tied to each and every student in the school system, and you could track their progress for, I think it was like 7 years. So we're talking 7 million students in this rich data to show what happens when a kid is suspended. The dilemma was that Texas A&M wanted to look at that data, and there are all kinds of confidentiality problems, as you might expect. And so they found a way to not identify by person each of the students they were tracking. And when they showed the data, they didn't identify the school districts because you have to think politically, if this data comes out, can we continue this, or is somebody going to resist it because they look bad in their communities? And so you would compare similarly sized school districts but not identify which ones they are. But we are learning who they are. The next dilemma, though, and the reason we need more data, is that with ticketing, there is precious little information. We don't know who's getting the tickets and what for. We don't have detail about is the assault because they pushed a fellow student or because they punched a teacher? We don't know that. And so we're trying to get the school district law enforcement officers to help us and to continue to get that data. Now, how do you get this done? It's tough. I think the way you do it is you begin talking about it in very candid terms and saying, we need this. We need to know what's happening in our schools. We just need to know it. It's useful for that purpose. But it's imperative, I think, to get the legislature on board. And we had a couple, both a Republican in the House and a Democrat in the Senate, that joined forces and said, we can do better. Let's get the data. Let's make some reforms so that it's not seen as a liberal or conservative issue, but one where all of us have a vested interest in doing better. There are states, and the Council on State Governments can tell you which ones are collecting data better and which ones are worse. We're in a very good position in Texas. I'm not sure if that was intentional or not over the years, but for those who are not, it's time to start collecting and getting the statutes that require that. Question.
Good evening. Name is Jessica. I have a question about the truancy and how that counts as a misdemeanor. I went to school in Austin, Texas, and we did have an officer that would actually arrest students on campus or on the school premises, and if they showed up after being truant, for so long, they'd be taken. But my question also pertains to how does this affect those students that are applying for DREAM Act? Considering it is a misdemeanor under Texas, and have you seen anything that says this is a problem for those students who would like to apply but are now barred because of Texas's misdemeanor for something as such of a truancy?
Jessica,
Yes, sir.
what I'm going to do is ask my committee to answer that question because I don't know, and that could be another impact of this. It's ironic, that the answer to truancy is to expel students from class, right? It just doesn't make any sense, and that's what is happening with the way these tickets are being worked out. I've talked to some principals, and there are many of them that say, no, what you have to do is get to know the kids and find out why the child is not making it to class and what is going on in his or her home life. Some of these kids are taking care of their infant kids, or their mother's other children, and it's very hard for them to leave, or they're working. There are all kinds of reasons, but there are programs that we can put in place to start bringing them to school. So this truancy, and that's one success point in Texas. We eliminated that as a basis for expulsion, but there are many other problems to address. Another question.
I'm Buzz Scher. I'm on the faculty here. You talked about the idea of right to counsel for those juveniles and those Class C misdemeanors. Is there any talk in Texas about actually doing that and how you would go about doing it? Would it be through a public defender system, a separate system?
Well, there's talk right now on our committee to evaluate the possibility of that. And in Texas, like everywhere else, everything is budgetary issues, and if you're not compelled, then the money is a lot of our money is already set aside for healthcare programs and school finance and that sort of thing. But I think something like a public defender system. The last 10 years in Texas, I really think we've come a long way, and you may think we should have been there, forever. But it took until almost 2 years ago for there to be a public defender's office in Harris County, Texas. there was no public defender in the largest county in the state and one of the largest in the nations. Well, how did they get lawyers? Well, there were local programs where the bar associations would either volunteer or pay money to hire, where the bar association could hire people to do this defense. But the result of it has been a much higher level of representation, more dismissals for cases that didn't have probable cause, and probably more efficient criminal justice system. So you can take that kind of model and say we should have the same thing in place here. And the truth is, if we get more pro bono, if we don't get paid public defenders, if we can get more pro bono lawyers in these cases, many of the cases go away. The resources are supplied because the lawyers know this is not a problem of, a bad kid, with a criminal mind. It's a problem of substance abuse or neglect at home or some kind of mental health problem where resources could really make the difference, or really, more of a consultation with the police officers. Why did you arrest this kid who threw a rock when there are many other things that could have happened? So one of the other committee recommendations is that before you suspend or expel, but certainly before you issue a ticket, that you try other measured means before you go to the end result of a ticket. So you make you start, if you can't do it through training, you say, here are some of the other things you do. Was there counseling? Did you refer them to this resource? And did you try in-school suspension rather than expelling? Different measures before you take the ultimate punishment of a ticket. These are things that I think can work. I don't see any other questions. Let me just end with this. I was amazed after I visited that school, the juvenile court proceedings, and decided this is something that people really aren't paying attention to, it seemed to me, and talking about it in the state of the judiciary. I was amazed at the positive reaction all around the state from all sectors and from business, from both political parties, from the people who are in the system itself. All of them want to help. Now, no one can come up with one solution, right? I mean, everyone has all kinds of ways to answer the problem, but it was, I think, gratifying to me that they recognize that there's a problem and they want to help and they want to do something about it. And it kind of surprised me, the telephone calls I was getting the next day. And I think that tells me people are ready in this country to focus renewed attention on our kids. I think judges should lead the way, and I say it not that judges should be lobbyists or that they should take the place of legislators, but what a judge can do is convene people together. You call the superintendent and say, I would like you please to come to a meeting, on January 10th, and at that meeting is going to be the chief of police of the school district police force. We're going to have social workers, we're going to have probation officers, juvenile judges, and we want to talk about what's going on and look at this data that we have examined. You can bring them together, and once they start talking, good things happen. That's been my experience, sir.
Yeah, I do have one question, if you'll take it. I'm curious as kind of the backstory to why this program was implemented in the first place. I taught middle and high school for a couple of years, and the way I frame these issues is really as a youth policy, and that the education system very much fits into the criminal justice system in other ways. And my experience was that the school systems were completely underfunded in many of the areas where I worked. I had 36 kids in a classroom, things like that. And so there were many days where, I would kind of joke with my colleagues, wow, I wish I could just get rid of this one kid. They're causing such a problem.
Yeah.
And of course, I was joking, but, when you're the principal who has this stack of of kids that's 3 miles long, and you're like, well, what are we really going to do? I can't even get through all this paperwork. So maybe if you could fill in a little more backstory of why this got started in the first place, and maybe the larger context of
Sure.
how the whole policy could be shaped to be better.
Sure, and you make an excellent point. And in Texas at least, and I think this happened in other places. In the '90s, there was this zero tolerance movement, and kids were now if you 1 strike and you're out, or 3 strikes and you're out, that sort of thing, and that helped lead to police forces and then Columbine, and every time there's a school shooting on campus, there's a reaction, and some of it is reasonable and some of it may not be. And so that kind of escalated in Texas to having school districts having their own police forces. But you make a good point. I mean, one thing I did I did this juvenile justice, stayed the judiciary, went to the court. Then I thought, well, I should go to a school, start looking and seeing what's happening in schools. And so I went to Houston, and there's a school, Cesar Chavez High School, which is in a bad part of town, or what we would consider bad. There's gang activity and drugs and all that. So I wanted to, walk around. And I drove there, got out of the car, and there were like 10 bulky police officers escorting me like I was in a cocoon everywhere I went, like I was going to be attacked, in this school, which I thought maybe doesn't send the right message. But then I went and spoke to teachers, and I said, you got to stop calling the police and ticketing all these kids. This is causing all this problem, and juvenile courts are getting. And they said, Chief, look, how are we supposed to instruct the rest of our kids? This kid is yelling and pushing and disrupting, and we don't have on staff somebody who can deal with whatever problems that person is going through mentally or otherwise. And if I can't get him out of my class, no one's going to learn, and we can't have that. So it is easy and easier to call the police and take this kid out. And then the police can do what they do, ticket, and then if they're expelled, they're gone, and I can focus on my kids. And I think that's a legitimate point of view, and it does. It talks about resources. What do we have? Why aren't we funding the schools enough to make sure that they have people in place that can look at this? And the teachers are saying, we have no training. If you're not going to give us a mental health officer or a psychologist or somebody here on staff, at least train us how to de-escalate these situations when they get out of control. And so it's, I sound like it's an easy answer. I was talking about this in one academic, from a liberal point of view, said there shouldn't be police in school at all, in any of our schools. And I'm thinking, well, that's not going to go over well either in Texas. There are some dangerous schools and some real problems. And, so these are, I sound like this is all easy. It's not easy. But I think you get people in a room, you get someone like you in a room and show the other side. Then maybe a legislator says, okay, we need a little bit more funding in this area. And without it, we can have all the best intentions. But the result will be no tickets, but also no instruction in that class. And that can't be the way we want to go.
My question is a lot like Chad's question, actually. I taught for a few years in a low-income school district, and one of the big issues was we had a lot of resource issues as well, just the way funding is set up, and I'm sure there's lots of data backing up, definitely backing up what you say, but they come from low-income communities where the majority of this is. And like the way funding's set up where I taught in Connecticut, it's paid by each different town. So you have the wealthy towns who are able to have lots of resources, hire lots of social workers, have all this extra help and support. And then you go to a place like Hartford, we have one social worker for 400 kids, and 40% of them have some diagnosed disability. And it gets really strained out, and it comes a lot to that. There were times where my principal would send kids home because we had absolutely no other way to do it. And you talked about really wanting to get to know the kids, and it's great when you really want to get to know the kids, but there's one of you and hundreds of other students, and it's tough. My question really goes to, how do we get a sort of communal sense for this? Because what happens in Connecticut, I know this in particular, it kind of becomes a NIMBY issue. It's like not in my backyard, where a lot of the towns right around, like you go to West Hartford, you go 6 miles away and you have one of the best high schools in the state. But those issues there don't have nobody wants to have anything to do with what's going on there. How do we get people to realize that this really is a shared kind of thing that we need to pay attention to, and it's really good not just for that community, but for community as a whole?
If you keep thinking about that, and if you come up with the answer, let me know. But I will say this: if you can get as I say, there are examples of the schools where you taught next door to examples with schools with the same kids, and the experience in those two schools is completely different. What explains it? I mean, they're coming from the same families in the same area, but somebody has found an answer. And I think what we need to do is bring those two schools together. They don't talk to each other now, and say, what are you doing differently? Or there are examples in Baltimore where great things are happening, and borrow from those examples and put them in place here. I don't know how you definitely bring the community together completely, but I think if you can get people talking, that's the beginning. And then if there is a change in statute that really has promise, then you become an advocate in the legislature and get that to happen, including funding, appropriations for this. And it turns out some of the money, you can save money by closing some of these detention centers and moving the resources closer to home. And that's been the experience in Texas. There are a lot of these juvenile facilities that are now sitting empty, and now some of the money is back in home, so that the kid is closer to home, closer to their parents, closer to a mental health professional right there in the neighborhood.
Good evening. First of all, I wanted to thank Dean Broderick for extending an invitation to members of New Hampshire Association for Justice. I'm a paralegal member of that organization. I work for an attorney. We do primarily family law and criminal defense. We have a lot of juvenile clients. I'm also the mother of a child with an individual education plan. And I have testified twice in our legislature in the past year against proposed legislation that would provide blanket immunity to teachers for using physical force, reasonable physical force, changing it from necessary to reasonable, to enforce decorum in the classroom. The reason this legislation has been proposed, we've been told, is because of an incident where a student assaulted a substitute teacher to the extent where the teacher required major medical intervention. And other teachers were afraid to intervene and save that teacher. Students intervened. Those teachers said that they were afraid of being sued. And so now they want to go to the other end of the spectrum where, as a parent, I lose my parental rights and my child is losing his civil rights as a student when he enters the building, knowing that if he were to make an obnoxious noise, that a teacher would be justified in grabbing him by the back of the neck and physically taking him from the room, bringing it from a battle of wills to a physical confrontation. So how are your teachers responding to what is going on in your state, where our teachers are asking for blanket immunity? And as a parent, we're saying we need to balance the civil rights of our children.
We're not having those same questions about blanket immunity or anything. And what I would say is that we're bringing the teachers in and asking them to be part of the problem. And what if it's my limited experience talking to teachers is the schools. My wife was a teacher for 10 years in a middle school, a public school in San Antonio that wasn't the wealthiest. The teachers that I'm talking to are saying, some of these kids, it's not just the conduct in school, it is what is happening before they get through the doors. Their nutrition is bad, they're abused at home, there's drug use at home or in between home and school, and if you can address some of these issues, maybe these instances of disorderly conduct will go down. But as to specifics on things like immunity and all that, I'm not equipped enough to answer that question directly. Thank you very much for your attention. This has been just fantastic. Thank you.
Before I present a small token to the chief, I wanted to myself acknowledge Mrs. Kenison, and what an honor it is to have you at this law school. As a dean, you're always marketing and always branding, at any cost and in any circumstance. And so when I have an opportunity to send the brand to Texas, I'm going to seize it. And so the first opportunity I have is now, and I'd like to present the Chief Justice with a hat that says UNH Law.
All right.
Hopefully you will.
Thank you.
But I hope more appropriately, Chief, I wanted to give you a crystal paperweight, which is done by Peppy Herman, who's a craftsman here in our state, as a token of our affection for you and our appreciation, not only for coming here, but for your eloquence and commitment to a pretty important issue. So I hope you will find a place for this on your desk in Texas, and remember the night fondly as we will.
Thank you very much.
Thank you very much.